Aloha mai kako. I am Camille Nelson, and I'm honored to serve as the Dean of the William S. Richardson School of Law. It's a real pleasure to gather today with all of you virtually. I sincerely appreciate your presence and engagement in these timely and vital conversations. They are critical. The Equitable and Sustainable Future Speakers Program is presently in partnership with the Hawaiʻi State Judiciary's Committee on Equality and Access to the Courts, the King Kamehameha V Judiciary History Center, the Hawaiʻi State Bar Association Civic Education Committee, and today, the William S. Richardson School of Law. The series is a collaboration that reflects our collective dedication to envisioning and building a legal system that is more inclusive, equitable, and attuned and calibrated to the needs of our unique communities. This event, Access to Justice, Public Accommodation, and the Future of Hawaii's Judiciary, is the second to last panel discussion of the series. On behalf of the King Kamehameha V Judiciary History Center, we extend our heartfelt gratitude to Chief Justice Mark E. Rechtenwald and the Hawaiʻi State Judiciary and Legislature for their steadfast support of this speaker series and for their commitment to fostering meaningful dialogue on issues that are core to our justice system. At the William S. Richardson School of Law, we teach our students that the law is not static. It is dynamic, evolving, and deeply human when operating at the highest level. Today, we are here not simply to analyze policy or critique systems, but to ask, how do we shape a judiciary that sees, hears, reflects, and serves all members of our community? Access to justice is not just a procedural issue, but a profound moral imperative. Law and morality are interwoven. Access to justice challenges us to confront how seen and unseen barriers limit participation in our legal systems. Whether through technology, language access, disability inclusion, or cultural competence, the work ahead requires us to be determined, innovative, empathetic, and collaborative. The conversations you will have today are forward-looking. Still, they are grounded in the urgent realities many across our islands presently face. Individuals for whom the legal system remains complex, distant, or inaccessible. Our distinguished guest speakers will guide a conversation that poses hard questions and seeks actionable answers. How do we ensure that technological advancements successfully increase public access rather than exacerbate the digital divide, leaving some communities behind? How can our courtrooms better serve individuals with disabilities, our kapuna, and our keiki? What does it mean to center language access, gender inclusivity, and the rights of immigrant communities in a legal system founded on equity? So let this space be one for shared inquiry, for bold ideas, and centering the voices of the most affected by the gaps in our system. The future of justice in Hawaii depends on how courageously we ask and how intentionally we answer the questions before us as we set a course for a better tomorrow. Mahalo to our panelists for sharing their time, for sharing their dedication to this work, and for their commitment to advancing equity and justice in our courts and beyond. I'd like to give the floor to our moderator, current Richardson Law student, Miah Bonilla. Thank you all.
Mahalo, Dean Nelson. Aloha mai kako, magandang hapon in Filipino, and mahalo for joining us this afternoon. My name is Miah Bonilla. I am a 3L Ululehua scholar and the Immigrant Law Clinic Assistant at the William S. Richardson School of Law. And I'm honored to serve as a moderator for this discussion. Now, I'd like to introduce our distinguished guests. First, we have Judge Rebecca Copeland, Circuit Court Judge for Oahu's First Circuit Family Court. Next, we have Lou Erdishek, the Executive Director of the Hawaiʻi Disability Rights Center. We also have Neribel Chardon, the Senior Staff Attorney for the Legal Clinic. And finally, Nikos Leverens, the Policy and Advancement Manager at the Hawaii Health and Harm Reduction Center. Throughout the discussion, I encourage our attendees to use Zoom's Q&A function at the bottom of your webinar screens to submit questions for our panelists to answer. We'll leave the last 10 minutes of the program open for Q&A. Also, a friendly reminder that this discussion is being recorded and will be posted on the Judiciary History Center's YouTube channel. Without further ado, we will start with introductions. Please introduce yourself, your organization, and briefly share how your work intersects with our theme of access to justice.
Thank you, Miah. So as Miah indicated, my name's Rebecca Copeland, and I am a First Circuit judge here on the island of Oahu for the First Circuit. I do currently sit on the family court criminal calendar. Prior to that, I was sitting in the family court in Kapolei. And so all of the individuals that we're discussing today, the issues that intersect with them, we actually deal with those on a daily basis, and I still do here at the circuit court. So, we have issues related to needing interpreters, language access, disability access, LGBTQ plus individuals, and most recently, protecting immigration issues as the folks come before our courts. So I actually do want to thank everyone for being here today as well. I'm very excited and interested to hear what you all have to say. I know most of what the judiciary is doing now, so I'm really interested to also learn from you on how you think that the judiciary can be better in how it's interacting with these various members of our community.
Aloha, my name is Nikos Leverins. I am the Policy and Advancement Manager with Hawaiʻi Health and Harm Reduction Center. Our mission is to reduce harm, promote health, create wellness, and fight stigma. And many of the people that we work with operate at the intersection of poverty, behavioral health issues, being members of sexual and gender minorities. And many of our clients have a disproportionate involvement with the criminal legal system, usually due to behavioral health concerns. Although even standing alone, sexual and gender minorities do have disproportionate involvement in the criminal legal system. We also have a transgender services program that helps folks with name changes and the applications with the Lieutenant Governor's office. And we also provide the transgender community with opportunities to participate in public events and group support on an ongoing basis to highlight, the vibrancy of the transgender community in Hawaii, given our indigenous culture as well. So I'll leave it at that right now. Mahalo for the invitation again.
Would you like me to go or Maribel? I guess it doesn't matter. Okay, hi, I'm Lou Erdishek. I'm the director of the Hawaii Disability Rights Center. So we're part of a national system called Protection and Advocacy, or known as P&A. This was actually founded back in the 1970s when Geraldo Rivera was a young reporter. He and actually the original Robert Kennedy, who at that time was a senator from New York, took a tour of a place called Willowbrook, where they found that people were living in these filthy, terrible conditions. And so Congress was shocked. And so it created a nationwide system called Protection and Advocacy. So there's one entity in every state. We were designated by Governor Ariyoshi back a long time ago. And so essentially we're a little bit like legal aid, although we're disability focused. We provide free legal and advocacy services to people with disabilities. And a lot of them, things like employment, housing, education, disability benefits. And as Nikos was saying, there's a tremendous correlation between disability and poverty and the intersection of the involvement in the court system. And so I think this discussion is very timely, and I'm happy to be included and happy to learn, happy to offer any insight that I can share as well. So thank you for having us.
Aloha, I am Maribel Chardon from the Legal Clinic. And the Legal Clinic is a nonprofit organization that was created to fulfill the gap in need for immigration legal services for those who cannot afford. Financials should not be a barrier for people to be represented in immigration court and before the USCIS, which is the administrative agency that will approve or disapprove applications for immigration. And TLC was created as TLC, Tender Loving Care. So the acronym came first, and then they need to find the words to match that acronym, and that's how the Legal Clinic was created. The Legal Clinic has 3 pillars. One is the direct immigration legal services, which are free for those who cannot afford. Also, we provide education, and also we provide advocacy, trying to oppose bad bills and try to push for good bills. And way more than bills, this is part of what we do. I am the senior staff attorney, and I am licensed in Puerto Rico. I've been practicing for over 20 years, and the first 12 years I was in Puerto Rico, basically doing labor and employment law from the employer side. Then I relocated to this beautiful Hawaii 10 years ago. I have been practicing immigration for the last 6 years, and I'm also a registered interpreter with the Hawaiʻi Judiciary.
Thank you so much for your introductions. Now I'd like to ask Judge Copeland, but other panelists, feel free to chime in. So the question is, how are the courts leveraging technology to better provide fair and efficient legal services to Hawaii's constituents?
Okay, well, I think probably everyone's aware that, during the COVID-19 pandemic, the judiciary did roll out wide use of the ability to do virtual hearings. And that occurred across the board in every court. I think there were only a few courts actually that would still meet in person during the height of the pandemic. And those were courts that were considered safety courts where in-person hearings were still necessary. And now that we're back to, our post-pandemic lives and everybody's out and about again, the judiciary continues to use Zoom as its virtual hearing platform in a really wide variety of types of cases. Those are both in civil courts and in criminal courts. Zoom virtual hearings are widely used in the district court, arraignment and pleas in district and circuit court. And even in the courts where it's now still deemed necessary that hearings need to be in person for a variety of reasons, particularly, for example, in family court type hearings, judges always retain the discretion to be able to hold those hearings virtually. And so we're still using that quite a bit. I think that's the biggest way that we've been able to employ technology over the last few years in order to ensure access to justice for the participants in court. And I think it really has, in certain types of courts, actually increased the ability of individuals to appear for their hearings. So rather than seeing a lot of defaults in certain kinds of cases, we're actually getting the people be able to appear, because if they do have issues that prevent them from being able to come to court, whether they're socioeconomic issues or disability issues, those folks can now appear virtually. We still do employ some telephonic hearings as well, because I do think there's some concerns about digital access that are proper. So there's telephonic hearings that can occur as well in many of the courtrooms if individuals don't have computers or internet access. So that's the main thing. And I do want to point out that so the judiciary is really kind of at the forefront in trying to figure out how AI, the dangers of AI, but also how that can be employed in a good way to help our users. And I was just notified prior to us going online that the judiciary did launch its own AI-powered chat. I don't know if I guess it's called a chatbot. A chatbot is called Kolo Kolo Chat, and that was actually released today in honor of Law Day. In addition, the judiciary does have a committee that it instituted on April 16th, 2024 to study artificial intelligence in the courts, so that we can try to figure out how to use that particular technology as well to better service the users in our court system.
Thank you, Judge Copeland. We'll definitely check out that chat box soon. Now, this question is for Lou. What are the current challenges in ensuring courtrooms, jails, and legal proceedings are ADA compliant?
Well, I mean, the courts have done a pretty good job in terms of the facilities have ADA access and so forth. There is an ADA coordinator that people can contact. My understanding is that they generally try to work things out with people. I mean, it's probably not a perfect system, and I think sometimes people have not always been happy, but it goes beyond the physical issues. There are issues, as I understand it, with people that are either deaf or hard of hearing, and I think that sometimes what happens is that because disability is so individually specific, I think the courts have tried to provide accommodations, but sometimes it's not clear whether an ASL interpreter is what's needed, or maybe the CART system. And I think there sometimes might be a tendency to kind of lump them all together and say, oh, okay, if you're deaf, okay, here's what you get. Whereas some people maybe, the CART might work better than the ASL. There's lots of problems getting ASL interpreters. There aren't that many of them. I know that we find that in our own practice here, because obviously we provide them as we need to, but you got to book them in advance, and they're not that cheap. And on the neighbor islands in particular, there's a huge shortage. So that has definitely been a challenge, I would say. We also have issues with people that have cognitive disabilities. I see cases coming in where people are requesting more time for, and I think that's an interesting question. I mean, so obviously you have rules of court and you have deadlines to follow, and as a lawyer, I can certainly appreciate that. When somebody is representing themselves, I understand human nature being what it is. I think no judge wants to be overly harsh on a pro se litigant, and yet at the same time, they're supposed to be held to the same standards that everybody else is when you file a lawsuit. Sometimes they request more time to file their briefs or their memos. So I think the question becomes what's reasonable, because the ADA generally has that reasonableness analysis. You're entitled to an accommodation as long as it's not unreasonable. So how much time is too much time? How much does the person need? These are kind of interesting questions and difficult questions. I can certainly say that whenever we've gotten involved, we've certainly found the courts willing to try to work with us, even if you don't always come up with a perfect solution. The courts have generally been pretty good about wanting to do it. But I know that we did have one case, which sort of a woman that got arrested, and when she got arrested, the police didn't give her an ASL interpreter, and then she was in jail on Maui, and they didn't have an interpreter, and then she got assigned a public defender, and they didn't have an interpreter, so they were trying to do a plea deal in court, and she didn't understand. So we got involved, and I think they then did provide an accommodation for her. So I'm happy that we were able to help her. But at the same time, it certainly does show you that despite the good efforts of the judiciary, challenges are always going to remain. And I think we're probably never going to have a perfect system, but the goal and the plan is to try to collaboratively work these out together.
Thank you, Lou. I think, sorry, did someone wanted to chime in? Thank you, Lou. I think that's a great segue to my next question. So you mentioned about, ASL interpreters. This question is for anyone. How important are interpreter services to ensure linguistic equity and fair treatment in court proceedings?
I can chime in, definitely, if I may. Yes, so for us at the legal clinic, language access is extremely important because we're talking about immigration. We're talking about people who are coming from other countries, and usually English is not the first language. So we will have people from, so if we're going to be talking about a little bit of statistics, let's say that in 2018, 266,000, 147 immigrants or foreign-born individuals comprise 19% of the population. And we are talking about that in the top countries of origins for immigrants here in Hawaii are the Philippines, 45%, China, Korea, Marshall Islands, Vietnam, and Mexico. So that means that at least those languages are priority. There is no way to talk about justice if it's not in your mother tongue. You will not be able to understand. But beyond that, even if people understand a little bit of English, can speak a little bit of English, when it comes to emotions, when it comes to in-depth thinking, you need to be able to communicate in your tongue language. But it's not only, and we need to also combine this not only with the language. Let's take Spanish, for example. Spanish is my native. I am from Puerto Rico. We have a lot of words that are only for Puerto Rico or that region. If I use the same word for other countries, people who come from Mexico or Honduras, they will not understand. So it is extremely important for the staff of the court, for the interpreters, not only to know the language, but to also to be culturally sensitive. We need to have that education. So how important? Well, there is no such justice. If there is no access to justice, there is no such access to justice without being able to understand the proceedings from the very beginning. I am not talking about only interpreters for hearings. I'm talking of interpreters when the police does an intervention with somebody. From the get-go, there is no way for the person to understand what is going on. If, like, for example, they are stopped and they're from Brazil and Portuguese is their first language, and the police officer is trying to conduct a sobriety test, there is no way. So it is not only just giving a paper if it is available, which is not available, but also having staff educated in different languages. Perhaps we can think about having interpreters being employed by the judiciary and the different agencies that, you know, have this huge responsibility. That's what I wanted to contribute.
I agree. And I will also say that in addition to the high emotions is even individuals who may speak some English, but it's not their first language. So perhaps in everyday conversation, they can hold a conversation in English. But once you get into the courtroom, not only are emotions high, but you also now are dealing with legal terms and just things you don't hear in your everyday life. So even for those individuals, we need to make sure that we are providing interpreters for them. And I think actually the judiciary statistics are 1 in 10 Hawaii residents or people that live here are limited English proficient. And so we do try to all of the languages that you mentioned, as well as a number of others. I also wanted to point out, I think everybody's probably aware of the executive order that came out from the president on March the 1st. And I hope that everyone knows that the Hawaii Judiciary did respond to that, did issue its own press release, and did reaffirm its commitment to providing language access. And to what Lou said as well regarding ADA accommodations and our are interpreters for individuals who need ASL interpreting. We are well aware of that, and actually the judiciary is already looking into trying to expand our repertoire of ASL interpreters and how to kind of deal with that issue, because we also see the same thing in pricing, right? Because we might only need somebody for 30 minutes, but what they're wanting is an entire day. So we're looking into those issues as well.
Yeah, I mean, I agree. We have the same problem. I mean, sometimes, and then and it's like $100 or $200 for like an hour, and then if you want, and then if it's going to be a little longer, they insist on you got to hire 2 people, because the first person is going to need a break, and so it can get expensive. There's no question about it, and they sort of have a monopoly on the situation because there's not that many, and you have to be certified. And so I think a couple of years ago there was a resolution at the legislature to try to get a group together to figure out how to expand the numbers. I think there used to be or is a course up at Kapiolani Community College. They used to have a program. So no, but thank you, Your Honor. I'm glad that the court is aware of it and obviously, making an effort to deal with it.
I also wanted to just a quick comment, and it is about it works for both sides, because it's not only helping the individuals who are limited in English, it's also helping with the efficiency of the system, because the judges have so much work, and not having interpreters or not having somebody understanding or having access, then that leads to continuances. And that is definitely not good for, either parties.
Thank you for sharing your insights.
Wait.
Hawaii,
Okay.
sorry, go ahead.
You're right. That really is fundamental. I mean, if you think about it, things like the example I had about a plea deal or anything, I mean, as the court would understand, I mean, the ability to understand what's going on is about as fundamental as it gets, right? So if you're, especially if you're in the criminal courts, I mean, the court is canvassing the plea to make sure that the person understands, and so if they don't speak English or they're deaf, and the court has to make an independent finding that you're satisfied that the person understood what they're agreeing to. And so this is really very basic, I mean, in terms of the integrity of the whole process.
I think the cultural aspect too that Narabel mentioned, for example, within, we've had to reach out to Micronesian communities to better foster those relationships, to understand the cultures and the different types of languages, to make sure that we have the correct interpreters in court. And that's been a real cultural reach out for the court as well. So I think all of those things we're always striving to make sure that we're providing, but it takes work. It takes behind the scenes work for people to make sure that those kind of things are happening.
Great. Yeah, I mean, I agree with all of your points. I think providing interpreters just promotes efficiency. It's basic, but at the same time also promotes efficiency, especially since there's so many, immigrants that make up Hawaii. If it's okay with you, I'm gonna shift gears. I wanna talk about gender identity and expression. I'm not sure if Nikos can answer this question, but other panelists, feel free to chime in. The question is, how does the state of Hawaii's legal statutes and court system currently approach the rights of transgender and non-binary users and employees of the courts? Nikos, if there's anything that's lacking that needs to be, we need to provide for our gender diverse population in the state.
I think I was going to save my comments on this toward the end, but I think I'm going to bring them up right now. First, I want to admit that we've made great progress through advocacy, through allies on the treatment of sexual and gender minorities in the courts, and that includes service on juries, Governor Ige signed a law in 2022 that provided that, people gender minority, the gender expression and gender identity was not cannot be a basis to strike a person from a jury. But so in terms of the treatment that sexual and gender minorities face in our system, I think it's a larger issue, really. I think the judiciary, in collaboration with, the public defender's office and the prosecutor office, really needs to take a look at the history of structural stigma in our criminal legal system specifically. But structural stigma also includes, our social systems, our medical care systems, and take a look at how people have been disproportionately impacted by the laws over time. Gender minorities, were pretty much de facto criminalized for quite a while. And there really needs to be an understanding that, there is trauma there that is still very much present in the community. At HBRC, we do offer courses on LGBTQ cultural humility that sort of explores this a little bit, because our sexual and gender minorities have disproportionate uses of well, they don't have disproportionate uses of substances, but they're also disproportionately treated in our system. So I think it's really important for the judiciary and the bars to take a look at substance use and substance use disorder from a non-criminal legal perspective. Take a look at sort of the science. Take a look at things like minority stress theory and adverse childhood experiences, so that people do not come into this system because they are generally doing well. Often, it's unfortunate that access to treatment only comes with involvement in the criminal legal system. So I think we really need to look at substance use and substance use disorder and even mental health as medical problems and problems that require a public health approach, as opposed to, you've one where criminal legal concerns dominate. So more education, more awareness that there are a multitude of factors that may be experienced by people who are present in their courtroom. And I'll just leave it at that right now.
Yeah, I agree. And I don't know, Nikos, if you work much with the family court. I think within the context of working with juveniles, and those who are part of sexual and gender minority groups, the family court has really made great strides in some of what you're talking about. But I do think those kind of issues need to be more fully addressed within the context of the adults who are coming into criminal court. But that's very good comments. I really appreciate it. I might actually be in contact with you later about these issues. I did want to highlight some of the things that the judiciary has done. So the Committee on Equality and Access to the Courts, which is one of the co-sponsors of this particular panel series, was the primary architect behind the judiciary's non-discrimination and non-harassment policy. That broad policy has been around for many, many years, and it's actually included gender identity and gender expression and sexual orientation as well, at least since 2017. So the Hawaii judiciary itself, from an employee perspective, has been protecting and emphasizing these kind of issues for quite some time. The Committee on Equality and Access to Courts actually has just completed an LGBTQ bench card that, once it is finally approved, will be pushed out to all of the judges so that they have that at their fingertips when they have individuals come into their courtroom, and is currently working on a similar bench card just specifically related to LGBTQ plus youth, because sometimes the issues can be different that the judges need to address. We do have consistent training on these issues, but I am interested, Nikos, in some of the things you mentioned regarding the other kind of more expansive type training. So that comment is very much appreciated because I think there are many of us in the courts who find this issue to be exceedingly important. Not that other issues aren't, they all are, but when you have a group of individuals that is such a small part of a population, but is so over impacted by these kinds of, substance abuse, mental health issues, interaction with the judicial system, that we are always looking for ways to improve in how we're dealing with this and interacting with folks.
I just wanted to add that I think that the community court model is a good mechanism to reach people who need to clear up some concerns, and to do it in a more holistic and non-punitive fashion, to link people with case management services and substance use services. We've hosted the community court here at H3RC. And the community court also received, I believe, baseline funding in this past legislative session. So that's a very positive development from the aspect of sexual and gender minorities and those with behavioral health problems.
Oh, yeah,
I'm-
absolutely.
Oh,
lot of-
sorry, go ahead. Sorry, go.
Impacts a lot of our clients too. I think the community outreach court is great. Because I mean, we're not criminal lawyers here. We don't represent them in the criminal court, but we have a lot of clients with substance abuse and mental health issues. And clearly this is a population that frequently is missing their court appointments, or they can't get down there. And then all of a sudden there's a bench warrant, and what might start out as a relatively minor issue somehow, exponentially explodes into a major calamity for these people. So I think the outreach, and so I really applaud the judiciary. I mean, for these kinds of initiatives, the outreach court kind of brings it to them, and making sure that they get prompted about when they have to appear, and plugging them into case management, because for the most part, what they probably need are services, mental health services, rather than incarceration. So yeah, I think that's a great effort.
Yeah, I'm glad to hear that we're making progress, that there is a lot of initiatives, especially from our court. Judge Copeland mentioned about juveniles and youth, and I think that's a good segue to my next question about Keiki in general. How does the court system, I think this is for all, but feel free to chime in. How does the court system currently accommodate minors, and what reforms could improve their experiences?
Okay,
Yeah.
well, I guess I'll start since it's related to what's happening. So I think what I've noticed is that most of the minors who come into the most direct contact with the court system are doing that at the family court. So whether it's in the context of juvenile offender cases, children who are part of cases involving the Child Protective Services, or even divorce, paternity, domestic violence type cases, all of those involve children. And so the family court in particular has done a lot of work in how it interacts with juveniles, and how those issues are dealt with, and how judges interact when they're having juveniles. So for example, in the child welfare services cases, the family court judges have worked really hard to try to maintain more, or I guess give more agency to the minors who are part of those, because they're kind of thrust into those cases. They're there because parents are there. And their lives are really put into turmoil because of that. So for example, for a little while now, the judges have been meeting individually. They have their guardian ad litems present so that it's not necessarily a one-on-one, but they meet with the minors to talk with them about how they're doing and find out if they need anything, to allow them to have a say in what's happening in the cases that are really impacting them the most. In the juvenile justice system, we've really worked hard with the juvenile justice reform, and sort of what I was saying before, which is the focus is really working on the services. What do we need to do for the juveniles that do come into the system to make sure that that's not perpetuating? So working with the minors, the caregivers, whether it's parents or guardians, the service providers, they have court officers, which are, you know, kind of the same as adult probation officers who help work the case, get the background, find out maybe what has led, you know, the family to this point or the minor to this point, and really tailor what they're doing for those minors to try to help the situation, get them to a better place so they're not continuing on in that same cycle. And the same thing kind of applies to the community court. You know, family court has a number of specialty courts as well, juvenile drug court, girls court, truancy court, where the judges are even meeting more specifically with a subset of juveniles who have specific issues that need to be addressed to make sure that there's some intensive work happening with them. So, I mean, I think I think some improvements, I mean, I think everybody knows about the Malama Working Group that came out with the recommendations in CPS cases. I know the judiciary is looking into some of those issues. And going back to the cultural sensitivity, making sure that our courts, and when minors are coming into those courts, that we're culturally sensitive in that context as well. And so, for example, Judge Jessie Hall, that's a very important issue for her. And I know she does a lot of work towards cultural sensitivities, particularly in the Native Hawaiian context.
On the line of services, I'd like to go back to immigrants in general. This is vulnerable, but other panelists feel free to chime in. What specific court programs or legal services support our diverse immigrant community?
Thank you for that question, because, you know, this is a good opportunity to pinpoint what is working, what is really working, and can be improved also, and certain things that, sadly to say, are not working. What supports the immigrant community? Definitely, number one, interpreters. That is awesome. Without we already talked about the importance of the interpreters, and so that will give them, you know, access. Also, this is not necessarily part of the judiciary, but they do a lot. And kudos to the DVAC advocates. Those ladies, because right now the only ones that I see are ladies, those ladies are warriors. And not only because they are very committed with their clientele, but also because they are culturally sensitive and also take care of language access. And they are there with the people. They are there with the individuals, which is extremely important. That leads me to the next thing that works, but I think that can be expanded to other areas, the friend of the court. That is very important because people feel accompanied, people feel supported, and they're not necessarily giving legal advice, of course not, but by sharing their experiences and being able to help out and support navigating the forms and the process and the procedures, that really helps. So if that somehow can be expanded, that will be great, especially within the immigrant community. Because more so now, with the change of policies and administration, a lot of immigrants are very, very fearful or appearing to court. So that's why remote hearings are very important. However, like Judge Copeland mentioned, it relies on the discretion of the judge. If we can expand that and we can do more remote hearings, that is great. Not only because there are parties who are on other islands, but also because, or remote places, but also because we know, and, you know, I'm going to put it out there, we know that there have been immigration interventions around the courthouses, not necessarily inside the courtroom, but around the premises of the court of the so it is very important because immigration, yes, it's important, but it is very important to protect people. And I'm not talking only about temporary restraining orders and family court matters, but people want to comply. People want to be observant of the law. People want to be responsible and comply with their court hearings. But if people are, number one, not understanding what's going on. Number two, they're fearful on going there. That will definitely help. And what does not support, and this is hard, sad to say, but court staff needs to be reinforced on the idea and the concept that there is some confidential or private information that people should not be asked in a public space or a space where others can hear, because sometimes, maybe because of lack of knowledge, they will ask certain questions that will point the finger at that person may be an immigrant or maybe out of status. And then that adds another layer of problems for that individual. So that is another thing. And so yeah, definitely what really helps interpreters, the DVAC advocates, the friend of the court, and the remote hearings.
I think you're muted, Miah.
I'm sorry. Thank you, Judge Copeland. So besides having more interpreters and improving physical accessibility, Lou, how can the judiciary better serve individuals with cognitive or sensory disabilities?
Well, I think we kind of touched on this point earlier, in terms of, as I say, the timeline issue for people. I think is a crucial one in terms of cognitive disabilities. As far as people, as I say, whether they need CART or ASL, I mean, I think understanding the individual needs, I think, is something that needs to be done. So yeah, I think that was kind of addressed a little bit earlier. I did see some questions in the chat that you might I saw there was a question about bail reform and things. I mean, if you want to talk about that, I mean, because we also represent, say, a lot of people with mental health issues, and the court, and I think to the extent that the court can accommodate all these behavioral health issues, I think that would be really important.
Yeah, I think this is a great time to look at any questions in the QA chat box. So I see there's two questions. I'll ask the first one. So the first question is, does the Hawaii Judiciary offer any accommodations for people coming into the court system for immigration cases who are fearful of deportation or other immigration enforcement? I think this might be for Narrowbell.
Well, I cannot speak, specifically on what accommodations the judiciary is offering right now. But the remote hearings are important, maybe not as an accommodation, but to facilitate access to everyone. So that not only applies to people who are out of status or maybe fearful about being intervened by immigration authorities, but think about it. Maybe this auntie who is an elder and who may not be willing or is not in good health to physically go to court, maybe somebody can help her with technology and then she can appear to court remotely. But again, expanding remote access, that would be good. Another thing is the education to staff I mentioned before, And also, I think that there is another key. And again, this is sad to say, but we do have clients that have confide to us that the reason that ICE intervened with them around or near or after court was because the probation officer called ICE on them. Yeah, that's extremely sad. And that should not happen because one thing is not related to the other. One is criminal, maybe, another one is immigration. And I think that if we want to instill trust in people in the system, then that needs to be permeating all the areas.
Thank you, Narabel. We have another question here. This question is
I'm
about,
sorry, before you say that, I'll just chime in to say, I agree that remote access, it's for many different individuals who may need that. The judge wouldn't necessarily know that, so I think the courts would have to rely on whomever is helping an individual to request in many times the remote access to be able to employ their discretion to allow that type of hearing to occur.
And so piggyback on that, that is why, again, this needs to be, we need, and I think we are all clear on that, we need to have a holistic approach. And part of that holistic approach is also maybe starting a program of navigators. You can call it court of the friends of the court or navigators, but people that can do that for those who cannot advocate for themselves. And I am not trying to minimize, I'm not trying to, but again, if we take care of each other as the way we're taking care of our elders, of our mom, then then our mindset is going to change. And then we're not going to be thinking about, oh, the immigrants, oh, the ones with, so it will give us a different perspective.
thank you, Narabel. I think I'd like to ask this question as we wind down. As we are almost at 1 o'clock, I think this is a question for everyone. So the question is, what long-term strategies should be implemented to create a more inclusive and accessible judiciary in Hawaii? I mean, we've talked about, having more services, education. If you could, if anyone has more to provide us, that'd be great. Lou, I see you're unmuted.
Sorry, are you asking about the bail reform question?
No, I'm asking just as a general question for everyone. Yeah, unless you wanna answer that question, then feel free to do so. I can ask that question. Sure. Okay, so yeah, there's this question about FTA. Could you please explain why or why not you would support bail reforms on forfeiture and bench warrants?
I'm a big believer in bail reform. I mean, and I think that it impacts our clients, but we're starting to talk earlier about it, somebody who starts out with a relatively low level minor offense and somehow it builds up. I've always been concerned that bail is used in a way that it shouldn't necessarily be used. The purpose of bail is simply to make sure if somebody shows up in court, unless they're posing a danger out there. And I've often thought that there's a real over-reliance on bail early on up front. And I mean, I've been here about 35 years, but I practiced in Connecticut for about 15 years, and I did small-time criminal work, and these people were always just automatically released on a written promise to appear. And so I think in other states, it's much more common to do that. And I think that you end up penalizing people, particularly folks with mental health issues, who end up languishing in jail simply because they can't come up with a few bucks to get out of there. And then their mental health decompensates, and it just leads to a whole other compounding of problems. So I know the legislature has passed bail reform. I'm not clear on whether it's been carried out by the judiciary or not, because they keep coming back every year with another bill. And I've always been a little puzzled because I thought, well, I thought they did pass it. And so it must not be working as well as some people think, because they keep coming back with more bills. But I think it's a very important issue.
Yeah, I think also in addition to mental health concerns, obviously it disproportionately impacts those lower income individuals as well, clearly. There's also a question, and if you don't mind, Lou, it's addressed to you, but I'll answer this one about whether or not individuals who are subject to Assisted Community Treatment Act proceedings in family court are guaranteed legal counsel. So the way the statute is currently written, they are provided guardians ad litem. The statute previously had legal counsel through the Public Defender's Office, and I think a couple years ago or so it was amended, right, Lou, to be the guardians ad litem. So that's what the individuals under ACT cases are provided in family court.
Right. I mean, I've been involved with that issue, and personally, I disagree with the decision that the legislature made a couple of years ago. And at the time, I opposed removing the right to counsel and appointing the guardian ad litem. The GALs typically are lawyers, that's true, but I think as the court could probably appreciate, they're there to act in what they think are the best interests of the respondent. Whereas an attorney, whether it's a court-appointed attorney or a public defender, is there to articulate the stated preference of their client, and that's what lawyers do. We try aggressively, within the bounds of the ethics, to represent the people that we are hired to represent. So I don't think that was a good decision that the legislature made, and I continue to believe that it is a due process violation, because while assisted community treatment is a good program, I'm generally supportive of the concept. I think it has a lot of merit. The truth is that if somebody doesn't comply with an ACT order, if push comes to shove, that person could be literally involuntarily medicated against their will, which, whether you think that's good or bad, clearly it's an invasion of a liberty interest that they have. And so to have gone through a legal proceeding that could lead to that result without having been represented by an attorney, I think is a due process violation. And I'm not sure that the GALs, they don't serve the exact same function, I think would be the distinction that I would draw. So yes, I continue to, I know last year they amended the law. This has been a contentious issue every year, Judge, and they did amend the law last year to give the court discretion to appoint an attorney to represent the individual if they felt that justice required it. There was no real criteria laid out. I mean, how do you do it and why do you do it? When do you, when don't you? It's really not clear. My understanding from the judiciary is that there weren't that many cases last year to begin with, and that attorneys were not appointed in any of those cases. They do appoint GALs, you're correct. I gather they're having a hard time getting GALs, and that seems to be causing a backlog in the system, which is kind of ironic because the people that were initially advocating to remove the right to counsel were doing it largely because they wanted to speed up the process. I mean, I'm not sure anybody necessarily thought that, oh, you absolutely shouldn't have a lawyer. They were concerned that lawyers were delaying the system, and they thought that appointing a GAL would give them some protection and yet would speed it up. But because there's no GALs, the system has been kind of stymied anyway. So kind of an ironic result.
So we're at we're past 1 o'clock. In the interest of time, I'd like to mahalo every panelist for joining me and attending this panel. It has been an honor to be a part of this discussion.
Miah,
Um,
you can go ahead and ask the questions in the Q&A. We go until 1:15.
Okay, sounds good. All right. So I was wrong. We have more time. So we have more Q&As. There's one question. I think this is specifically for maybe for Narabel or Judge Copeland. What protections are there for the court, judges, and clients in the event ICE agents come to arrest an immigrant?
Well, I cannot speak to what protections specifically are out there, from the judiciary as an entity. I can say as general information that there was a memo that designated some protected areas, and those protected areas were the places of worship, churches, schools, hospitals, places where funerals were taking place, and some others, including courthouses. Sadly, that memo is no longer in effect. So that means that there are no protected areas. That being said, ICE can conduct whatever activity. However, it is an administrative decision with the judiciary on what protections or what protocols or guidelines they would have. So far, the information that we have for the judiciary, for the judicial system here in Hawaii is that ICE has not gone inside courtrooms yet, but we know that that happened on another state, and the judge, Warrior, she took the person inside, and now she is being charged with obstruction of justice. So I cannot speak to the specific protections. I can only say as a general information that that memo has been revoked, so there are no protected areas. So that's why we are trying to apply preventive measures instead of remediative.
Great. So there's another question about accommodation. Might be a question for Judge Copeland or Lou. So if a person requests an accommodation at court due to a cognitive or other disability, with the accommodation requested to bring an individual with them to assist with communication, at some point, does it become an authorized practice of law?
I was hoping the judge might answer that one, because I mean, that's a good, that's a darn, it's a darn good question that I haven't really considered. I mean, this is not a well-considered opinion, but I can give you what my initial reaction, I guess, would be that as long as the person, I mean, if the person is giving it legal advice or things like that, then I think it would probably, border into the unauthorized practice. If it was simply someone who's just kind of parroting what you say, or somehow makes you feel comfortable and is able to help you, then maybe arguably that would not be considered representation. I mean, I think the court would probably have a more definitive word on this, but that would be my initial reaction.
I have not actually had that happen or heard of it occurring, but I do know that those kinds of issues are often addressed by the Office of Equality and Access to the Courts, which is the office of the judiciary, where ADA accommodations can be arranged, are requested and arranged. So I would assume that office would be the best individuals to reach out with a question like that. And then the good thing about contacting the office is they then make connection with the court and make sure that everybody's on the same page about whatever kind of accommodation is being made, so that we know what's going on when folks are coming into court.
I do have a personal question for Nikos, if it's okay to ask my question. You talked about the community work model. Could you elaborate on that?
I-
You were
I was speaking about the community outreach court model where you have people who may have had a failure to appear and who have, you know, things that will impede their ability to, you know, may perhaps remain outside of jail, and also sort of you know, deter if they do have a job, that might be problematic as well. So the community outreach court model takes these people who generally don't pose a risk to public safety, and clear up their outstanding warrants, for example, for failure to appear, and also it provides them with a bridge to needed services, whether they be medical services, behavioral health services, or housing navigation services. You know, if you're unsheltered or if you're at risk of homelessness, you often do not even know, you know, what day it is. So there needs to be, you know, a more concerted effort to get people and to make sure people are aware of what's going on in the court system. And if I could segue into the future of Hawaii's judiciary question here about creating a more inclusive and accessible judiciary in Hawaii. You know, we have very good non-discrimination laws in Hawaii, including gender identity and gender expression in non-discrimination. But you know, as a functional matter, I think you know everybody involved in the access to justice square really needs to understand that there are persistent disparities in health and access to needed services. Income is the foremost determinant of health. And in that regard, I think the judiciary and its policy team, I make a heartfelt request that, you know, when subjects like bail reform come up or sentencing reform come up, that they take that into consideration a little more than just sort of a reflexive bureaucratic opposition to being messed with, so to speak. For example, here's one example. We had a excited delirium bill in the legislative process this past session, which, you know, would have, the excited delirium is something that no real medical expert no longer recognizes. So we want to take it out of, you know, the medical system, but we also wanted to take it out of the legal system as well. Just as we took gay panic out of the legal system. So I would be hopeful that when opportunities to reform our laws arise, to equalize treatment of people, particularly those who, you know, might be subject to forcible restraint, tasering, etc., that, you know, our systems of justice recognize that, you know, people often need, you know, recourse, and that, you know, the continued inclusion of excited delirium in our system of justice, including civil court, represents a barrier that need not be there.
Yeah,
Just as one example.
Oh, yeah, I just want to, I mean, we were very involved in that bill as well. And I was concerned that, I mean, because the legislature most of them were very supportive. I think one of the big reasons why it didn't pass was that the evidence committee at the judiciary took the position that this should be a case-by-case determination, you know, that it's an evidentiary rule. Let the trial judge decide whether to allow them to admit it into evidence or not. And as a longtime practicing attorney, I'm certainly sympathetic to that. I can appreciate that, but echoing what Nikos is saying, apparently this theory has been so debunked that it was so unreliable that it was causing a lot of confusion. And I think and California about a year or so ago passed a bill saying that you could not admit that into evidence. So we were trying that here based on a case 10 years ago of Sheldon Halleck, who was killed on King and Punchbowl Street. And so clearly the underlying answer to that problem is better police training in terms of how to deal with de-escalation of people with that have mental health issues. But in that case, they sat on him and they choked him, and then they basically used excited delirium as a defense, and apparently it did confuse the jury. So the bill still sits in conference, and I did speak to some people at the judiciary who seemed willing to engage in discussions in the interim, and I would hope that we can do that we can maybe talk with the evidence committee and hear their concerns, let them hear our concerns, because the committee met, it did take that position, but nobody from the judiciary actually showed up at the legislative hearings. That's kind of where all these discussions usually go down, and we get to go outside the hearing room and talk about it. I think what happened is that because the judiciary was opposed to the bill, but they also weren't there, I think that made people a little unclear about what to do. So I'm hoping we can dialogue better on that issue in the interim. And Judge, I don't know if you're involved with that committee or not, or if you're in a position to do anything about it, but I think more discussion would be very helpful.
Yeah, I'll just say, kind of in closing, not really directly on that, but it is a good point to be made that, you know, continuing discussions and education, for folks on issues is always important because, you know, folks don't always know everything about everything, like not, you know, all of us don't. So, I mean, I think as we continue, to reach out and our various organizations talk about these types of things, the more education we can provide when we're having those talks, the better. I mean, I did very little work at the legislature before I was a full-time judge, but it was related to transgender bills. And that was always the biggest factor, was making sure and like actually talking to people and having that reach out and trying to have those educational opportunities. So I appreciate you, Lou and Nikos, for being willing to do that for those types of issues, as well as anything else that comes up, and Narabelle as well. You know, this whole series, the purpose of it is to continue to have those conversations. So my hope is that all of us here today on the panel, but also everyone who's attending virtually and listening, what you hear today, to not just forget it, to remember what you hear, to talk about it and to keep talking about it, so that changes that can be made and need to be made, that we can find the space to be able to do that.
Very well said. This was a great discussion.
Thank you. So Brianna, I think we've hit 1:15. I think that's my cue now.
Yes, mahalo.
Yes, so thank you so much, everyone, for attending. And like I said, it's an honor to be part of this panel. I will echo what Judge Copeland said. Please continue the conversation. There's a lot of things we've discussed today, but hopefully we've left an impression and we've started a conversation that will carry on. But mahalo for today's session.
Yes, thank you all so much for participating. I really appreciate it.